Hello again, class. Today's lesson will be the second part in our pair of lessons on the Judicial Branch. Today we're going to focus solely on the U.S. Supreme Court, all right, the highest court in the land. All right. As you can see in this picture, there are 9 justices on the Supreme Court. If you recall from last class or last lesson, when the Federal Judiciary Act of 1789, when it initially established the Supreme Court, put 6 justices on it, but they've since added 3 more justices. That way it's not going to have a tie anymore with an odd number of justices voting. So you have 9 justices on the court now. They're appointed by the President and confirmed by the Senate. So whenever there's a vacancy on the court, which at the time I'm recording this was just a couple months ago, the President selects a name, meets with his or her advisors, decides upon a potential nominee, the President officially nominates a person, and then the Senate has a series of hearings. They interview the candidate for 2 or 3 days, and then the Senate votes. As long as they get a majority of votes, so 51 to 49, will confirm that justice. And really, that's all the Constitution says about who can serve on the court: someone who's nominated by the President and confirmed by the Senate. Otherwise, the Constitution doesn't really give any other requirements to be on the Supreme Court. So technically, you don't even have to be a lawyer to be appointed to the Supreme Court. Now, I can't tell you the last time a non-lawyer was put on the Supreme Court ever. Certainly, in modern times, from a practical standpoint, you're going to need to be a lawyer to be nominated by the court. But that requirement's not actually in the Constitution. And once someone makes it to the Supreme Court, they are there for life. Right? They serve out their term until they either die or retire. And out of the last 3 openings of on the court, 2 of them were from members actually dying while they were still serving, and 1 was a retirement. Now, let's talk about who's actually on the Supreme Court. As I said, here within the last really few weeks of when I'm recording this, we have a new justice. If you see the picture of the 9 of them, that picture is a little old. Ruth Bader Ginsburg there, the second from the right on the front row, sitting in the chair. She passed away a couple months ago, and the President appointed a new justice, we call them justices on the Supreme Court, Amy Coney Barrett, and you see her getting sworn in there on the right. So we don't even have an updated picture of all 9 justices together. She's such a recent appointment. All right, so who are the judges? And I'm going to put these in the order that they were appointed. First, Judge Clarence Thomas. All right. He was appointed in 1991, so he's been on the bench basically 30 years now. He was appointed by the first President Bush, George Herbert Walker Bush, back in 91. Then President Clinton nominated Stephen Breyer in 1993. Clinton also appointed Ruth Bader Ginsburg during his time in office, but as I said, she's recently passed away, so she's no longer on the court. But she was since from the 90s until 2020. Next, we're going to jump ahead to 2005. George W. Bush appointed John Roberts. He also serves as the Chief Justice of the Supreme Court, which really doesn't give him any extra rights in terms of voting power. When they vote on cases, it's just, all 9 get an equal vote. But he does have some additional responsibilities in terms of, administrative and organization, things like that. John Roberts is the Chief Justice. In the next year, Samuel Alito was also appointed by George W. Bush. Then Sonia Sotomayor was appointed, President Obama's first year. A year later, President Obama appointed Elena Kagan to the court. And then you had a 7-year gap until President Trump nominated Neil Gorsuch. He appointed Brett Kavanaugh to the court a year later, and finally, in 2020, President Trump appointed Amy Coney Barrett to the court. All right, so those are currently your 9 sitting justices. All right, so let's talk about the jurisdiction of the court. Remember when we talked about our last lesson, jurisdiction, just a legal word meaning basically the power and the authority to hear a case. All right. And again, as we talked about in the last lesson, Article 3 of the Constitution is not very detailed, it's not very long. It doesn't set out a lot of rules and things for these court systems. So it doesn't say much about what the court's power is or jurisdiction is. The court has, and in this lesson, when I say the court, I'm going to be talking about the Supreme Court. The court has jurisdiction to hear cases involving foreign officials, cases involving a state, so when a state's an actual party to a case. Now again, be careful, you understand this. That doesn't mean any government official from a state being a party. I mean the actual state itself. All right. So if Texas, if there was a lawsuit, Texas versus Oklahoma, and they were arguing about, water rights on the Red River or something, Supreme Court would have jurisdiction for a case like that. Okay, when a state's an actual party. And then third, it's just appeals from the circuit court. All right. Remember, we ended last lesson talking about the 13 circuits. All right. So let's go back and look at these slides here in a minute. All right, so remember you have this pyramid, you have the district courts at the bottom, then you have your 13 Court of Appeals, those are the circuit courts, and then the Supreme Court sits on top of those. Again, here's the map. All the states are divided into regions, and they are each region has its own circuit court. Well, that's the Supreme Court's jurisdiction primarily. That's what most of the cases the Supreme Court hears are appeals from these circuit courts. However, keep in mind, this is very important, the Supreme Court gets to decide whether to hear a case or not. At least that's almost always true. All right, so if you think about a district court, whether it's a federal or a state court, say you get in an argument with your next door neighbor. Say, his or her fence fell down and damaged, your prize plants or something. And you sue your next door neighbor. And you go and file that at your local courthouse, that court doesn't get to decide whether to hear the case or not. That court doesn't get to say, you know what, I've already had 3 cases this year about neighbors suing each other. I don't really need a 4th one. There's nothing new to say on this topic. The district court or trial court doesn't get to say that. Trial court has to take all cases that get filed in his court, assuming they're, within his jurisdiction in terms of geography and things like that. But otherwise, district courts have to take whatever case is filed. If the government is suing someone in a federal district, or not suing someone, is prosecuting someone in a federal district court for robbing a bank, that district court judge doesn't get to decide, well, I had a couple bankruptcy cases last year. I don't want any this year. I'm not going to take this case. Courts don't get to decide that, except the Supreme Court does. The Supreme Court can absolutely decide whether it wants to hear a case or not. And a lot of times it will on those types of issues. It may decide, well, you know what, we've already written about free speech twice this year. There are other topics we need to focus on as well, or we don't have anything new to say about it, so we won't take this case. All right. And so most people think if the Supreme Court refuses to take an appeal from a circuit court, it means that the Supreme Court agreed with how the circuit court ruled. And that's not necessarily true. It may be true, but it's not necessarily true. It could just be that the court believes either it's not yet time to talk about a particular legal issue, or that they've already talked about it enough in the recent past that they don't need to do so again. Or it could just be that they don't think that case for whatever reason is the best case to talk about a particular legal issue. They have all sorts of reasons to refuse to hear a case. and it doesn't always mean that they agree with the lower court. It just means that they don't think that's the right case for them at that particular time. So, a party who wants to hear their case, or who wants their case to be heard by the Supreme Court, must file what's called a petition for certiorari. And the Supreme Court, what we call grant certiorari, or grant cert, that's usually how it's going to be said, grant cert, which just means accept. The Supreme Court only grants cert in between 1% and 5% of the cases or the petitions that are filed. All right, so that means someone filing a petition to the Supreme Court may only have about a 1% chance of the Supreme Court actually taking that case. Okay? In a typical year, the Supreme Court hears between 100 and 150 cases. In some statistics I was looking at recently, and I forget the exact year these statistics came out of, but it's been in the last couple. There were, I think, around 7,000 cases filed in the Supreme Court in a particular year. And again, the Supreme Court's going to accept somewhere around 100 or 150 of those, thousands and thousands of cases. So, most lawsuits, the overwhelming majority of lawsuits, are not going to end up at the Supreme Court. All right. So when you hear someone say, "Well, I'm going to take this all the way to the Supreme Court," they might try, but they're probably not going to get there. It's fairly rare for a case to make its way to the Supreme Court. But if a case does get to the Supreme Court, here's more or less what happened. And I'm going to simplify this down, obviously, but here's basically how it works. Lawyers for both parties will file their arguments in a document called a brief. All right, Supreme Court, they don't call witnesses. All right, there are no witnesses. It's not like the court cases perhaps you've seen on TV or in the movies, where a witness takes the stand and a lawyer questions them. That's not what happens at the Supreme Court. There are no witnesses. There's no jury. It's just the 9 justices and the lawyers. And so, initially, when the case is filed, the Supreme Court accepts a case. The lawyers will have deadlines to file their written briefs. And what the briefs are saying basically why their side should win. Again, most of these cases are coming from appeals from the circuit court. So if a party lost in the circuit court, they're going to write a brief explaining why it was error for them to have lost, how the circuit court or the district court below made errors that need to be reversed by the Supreme Court. If the party won in the lower courts, however, that party is going to write a brief explaining why it was correct that they won and how the district court and circuit courts did in fact make the right decision. All right? And those written documents, those are legal arguments, are called briefs. So the parties file a brief, then the court sets a date for oral argument, where the attorneys take turn arguing their case to the court. So if you look at this picture, this is exactly kind of how it works. You got the 9 justices sitting up in a really tall bench, they'll call it, with the lawyer standing in the middle behind the podium arguing their case. And arguments are usually limited to 30 minutes, and the justices will often interrupt the attorneys with questions. Right? So, the lawyer may prepare a 30-minute argument, but they're rarely going to be given that full 30 minutes. The justices are going to ask some questions. Sometimes it's for things they really may not know about the case or don't understand about the party's position. Other times it's basically a ways to sort of probe for faults or defects in the argument. And sometimes it's ask the attorney, what would be kind of easy questions, because that justice is trying to convince some other justice on the bench of their position. So they're using the lawyer to kind of answer these pointed questions that really may be directed at other judges. So there's all sorts of reasons the judges may ask questions, but they typically do. And then, just like there are very few cases that end up at the Supreme Court, there are really relatively few attorneys in the country who specialize in handling cases at the Supreme Court. You're going to have a handful in the Washington, D.C. area. And then, If the government's a party, the government has a special lawyer called the Solicitor General that usually argues cases from the Supreme Court. All right, so 99% of all lawyers, probably higher than 99% of all lawyers, will never argue a case to the Supreme Court. Now, and I always find it interesting that, for most lawyers, arguing a case to the Supreme Court would be a once-in-a-career opportunity. But as you see up there, each side is limited to 30 minutes. So, even if the lawyer gets this once-in-a-career opportunity to argue to the Supreme Court, they'll spend weeks working on the briefs, but once they actually get to the court, it's basically over in about an hour. All right. Now, before and after oral arguments, each justice will assign one of their clerks. All right, and a clerk is a young lawyer, usually out of law school. At the Supreme Court level, they've probably been this is probably their second year out of law school. They probably clerked for a circuit court judge or maybe even a district court judge, and then they got hired by the Supreme Court as a clerk. And each justice has, I believe, 4 clerks working for them. And these young lawyers work for the justice for a year or two. And they're assigned to research and analyze the issues that each of the cases present. All right, so sometime both before and after oral argument, each judge is going to have one of their clerks research and analyze the issues that the attorneys are discussing. And then eventually the justices meet and vote on the outcome of the case. All right, and it's as simple as that. There's 9 justices who vote. So whichever side gets at least 5 of the votes, they win. Now, if the justices vote unanimously, i.e. it's 9-0, the Chief Justice assigns a justice to write the court's opinion that explains the court's ruling. Now, the Chief Justice can also decide to write it themselves, but if they're not going to write it themselves, then they assign it another judge. And this document that the court releases is called an opinion. It's a legal opinion. Be careful about that word opinion. I know we're often taught in school an opinion is something that can't be proven. It's not necessarily a fact. It's what someone feels or believes, like I like chocolate ice cream better than vanilla ice cream, that being an example of an opinion. But that's not really how the word is being used here. Because once the Supreme Court decides a case, it's not opinion anymore. It is legal fact. No one can legally argue with them. Now, individual people may not like the ruling or they may disagree with it, but legally that ruling becomes the law of the land. No other court can disagree with it at that point. It would take another Supreme Court case in the future to overturn it. So when we talk about the court's rulings being written in a quote, opinion, be careful of that word. It means it's something a little different here. It's really just a written document where the court explains what they ruled and why they ruled that way. Now, if it's not a 9-0 vote, if it's 5-4, 6-3, 7-2, or 8-1, however it works out, if the vote is not unanimous, then the group of justices with the most votes is called the majority. They got a majority of the votes. And the group of justices who didn't get the most votes is called, say, they dissent. Dissent means to disagree. They're in the dissent. And at this point, each group would pick a justice to write an opinion explaining the reasoning. All right, so the majority, one of the justices in the majority would write an opinion saying, okay, this is what the court is ruling, and this is why they ruled it. And then one of the dissenting justices would write what's called a dissenting opinion, and explaining why they believe that the majority was wrong. And so the dissenting opinion may not be, hold on just a second. All right, sorry about that. Someone came in my classroom and wouldn't leave until I talked to them. So what I was saying is the dissenting opinion explains why those dissenting justices voted the way they did. And finally, any justice on any case can write what's called a concurring opinion. This basically, concurring means in agreement. And this explains why they agree with the majority decision. Okay, so even in a case that's 9-0, someone will be appointed to write the majority opinion, or the opinion for the court. But any of the other 8 justices can decide for whatever reason that they also want to write an opinion. And basically it's saying, look, I agree with the way we ruled, but here are my thoughts on this particular issue. All right. The last thing we're going to talk about is judicial philosophies, and I want to issue a warning. You don't actually have to write this warning down, but just understand it. We're going to talk about these like these are, I'm going to show them to you. They're going to be in writing. They're going to be in print, and it's going to give the idea that these are very exact definitions. They are not. People don't always agree on the exact definition of these philosophies, and justices may not even specifically use one exact philosophy on every case. So, be careful, about treating these philosophies as being really 100% hard and fast rules. I mean, they're more parameters, I would say, because you will see, and when I say people arguing about it, I mean judges themselves or legal professors, people who study this for a living may have differences in how they're using these particular terms when they mean a philosophy. All right. 1, judicial activism. This is a belief that courts should be ready to overturn laws or regulations or actions, especially to protect or establish rights. Okay? And, when you hear judicial activism, it's often mentioned as a criticism, this idea that courts are substituting their judgments, their opinions and beliefs, in favor of elected officials. Right? So remember, at least in the federal courts, judges are not elected. And so, there are people who have a hard time accepting the idea that these unelected officials get to substitute, what they think about an issue with what a group of elected officials decide. All right, so a lot of times judicial activism is used somewhat as a criticism, but I'll also let you know, beauty is in the eye of the beholder, so to speak. All right? People have a hard time with judicial activism when a court may have ruled in a way that they didn't like. But most people aren't going to complain about judicial activism if a court rules in the way that they want it. So again, it kind of comes down to, whether the result of the case and whether you like the result or not. But nonetheless, judicial activism, it is a real philosophy out there. Judicial restraint is exactly what it says. The idea that courts should refrain or restrain themselves from overturning laws or regulations written by elected officials. This also extends to prior court holdings, or what we call precedent. Those are previous court decisions. That courts should try to restrain themselves from overturning prior court opinions. Now, those first two really deal with whether a judge should assert themselves into an issue or not, or court should assert themselves into an issue. These next 4 we're going to talk about are more philosophies about interpreting laws or interpreting the Constitution. All right, so originalism. This is interpreting a law based on how the original drafters or writers of the law would have interpreted the law. Okay? So when we're talking about originalism, let's talk about the Constitution. The Constitution was written in 1787. The Bill of Rights were written just a couple years after that. And so if we want to know, if you were an originalist and you wanted to know whether something fell within the prohibition, the 8th Amendment prohibition against cruel and unusual punishment, what you would want to know is, what did people like James Madison, George Washington, people who were there at the Constitutional Convention, what did they think was cruel and unusual? And that's how you would have to rule today. All right, so if you're an originalist, you don't believe necessarily that that what is considered cruel and unusual has changed over the past 230 years. You contrast that with someone who believes in what's called a living constitution, that the Constitution basically changes with the times. what we consider cruel and unusual now is different than what they would have in 1790. And so therefore these provisions should be interpreted differently. All right, those are two very kind of polar opposite points of view. One says you should really look to see what the people who wrote the Constitution. Well, it doesn't even have to be, when you're talking about originalism, it doesn't even have to be a Constitution. It might be some law written in, say, 1960. And what did the legislature believe in 1960 were the meaning of those words. All right, so those are two different philosophies. Whether it's kind of once something's written on a paper, that meaning stays fixed and never changes, or whether it sort of changes with the times. You also have what are called strict constructionists. And in this one, you interpret a law based on a strict definition of the written words and nothing else. You don't necessarily care about what people intended when they wrote it. You don't care. You don't even care if this leads to some type of absurd result in that case. It's like, well, this is exactly what the text says, and so we're going to interpret it based on a very strict definition of these words. We're not going to look at the context. We're not going to try to interpret what the people who wrote the law meant when they wrote it. None of that. You're just going to look strictly at the words. Again, contrast this with textualism. Textualism, you're interpreting a law or regulation based on the text without looking at outside evidence. Now that's that sort of part is similar to strict constructions. You're not going to look at what did the legislature intend when they wrote this law? What did the framers intend when they drafted this part of the Constitution? You're not going to look at that. But a textualist is going to try to interpret it in a somewhat reasonable way. They're not willing to interpret interpret the word so strictly and narrowly that it's going to lead to an absurd result that everybody agrees is not how it should come out. A textualist is going to look at the text, but try to take somewhat of what they would probably say is a common sense approach to it. All right. So again, those are various judicial philosophies. You see these at the Supreme Court as well as lower court. All right, and again, understand them, understand their differences, but also realize that people using these philosophies may not even agree on the definition, and a lot of times people won't even agree that they're using a particular philosophy or not. Others may say, oh, this judge is a strict constructionist, or this judge is an originalist, or what have you. The judge may not view themselves that way. All right, so we have these philosophies, but they're not necessarily hard and fast rules. All right, that concludes our lessons on the judicial branch.